Okay. Is that a yes or no? Listen to my question. Is it any different than the last motion to stay proceedings you filed? Listen to my question. Is it any different than the last motion to stay proceedings? Just give me what you've added since the last one, because this one I haven't had a chance to read fully. Give me the first one I read added since the last one, because this one I haven't had a chance to read fully. The first one I read fully. Okay, hold on. Listen, Mr. Cazell, this is going to be a very long day for you if you don't listen to my questions and answer my questions. This is going to be a very long day for you. Motion to stay proceedings. If you don't listen to my questions and answer my whatever's new, that was in the original motion to stay proceedings. I've asked you to give me whatever's new in this motion. Okay, stop right there.
Sue the Secretary of State.
How is that lead to why this should be stopped today? How is that lead to why this should be stopped today?
A while ago.
That's not the way it works. Mr. Cazell, hold on.
Stop.
Hold on.
A while ago.
Hold on. That's not the way it works.
Okay.
Mr. Cazell, hold on.
That's the last time you're going to interrupt me today without a contempt of court charge. Is that clear? That's the last time you're going to interrupt me today without a contempt of court charge. Is that clear? Is that clear? One more word. And it's contempt of court.
No one has made her.
It's $100 a contempt, and if I get contempt of court, totally fed up with it, then I'm putting you in jail. It's $100 a contempt, and if I get just because she and I happen to agree on the law as it applies to your case doesn't mean we're in collusion. Just because she and I happen to agree on the law as it applies to your case doesn't mean we're in collusion. Accept the possibility that she and I have the same opinion about something. That doesn't mean we're colluding. Accept the possibility that she and I have the same opinion about something. That doesn't mean we're colluding. Do you understand that concept? You understand that concept? I am impartial. I've been trying to understand that concept. Just because I agree with the prosecutor doesn't mean I'm against you. I've been trying to say I agree with the prosecutor. Just because I agree with the prosecutor doesn't mean I'm against you. It just means I agree with the prosecutor. So that means in any case, when I buy the argument from one side, that means I'm colluding against the other. When I buy the argument from one side, that means I'm colluding against the other. No, you have to answer my question. Yes or no, Mr. Crucell. Contempt number one. No, you have to answer my question. Answer my question. Contempt number one. Every time I rule in favor of one side, does that mean I'm colluding against the other? Yes or no? Every time.
This is the first major disconnect. The defendant is equating agreement with collusion, which legally makes no sense. Judges are required to evaluate arguments and rule for one side. That's not bias, that's literally the job. But watch closely here. Once someone adopts this mindset, every ruling becomes proof of conspiracy in their head.
That's what judges, by definition, have to decide in favor of one party or the other. What statement is that? I thought we were talking about Judge Green's SOS statement. What statement is that? I thought we were talking about Judge Green's SOS statement. The prosecutor is Mr. Crucell, what I was doing was aligning myself with the law as I see it and interpret it. Mr. Crucell, what I was doing was aligning myself with the law as I see it and disagree with me and move on. Stop. If you don't like a ruling from a judge, you have to appeal that ruling. Disagree with me and move on. If you don't like a ruling from a judge, you have to appeal that ruling. You don't just, brother, listen. You don't keep arguing with the ruling. That's not the way the process works. Save you from yourself. Listen, brother, listen. I have tried, if you remember, the first time you were in my courtroom, I tried to get you to see things the way the process was going to move forward. If you remember the first time you were in my courtroom, dude, I tried to get you to see things the way the process was going to move forward. You might not like that, but I'm in charge of the courtroom. This process is going forward the way I want it to move forward. If you don't like anything I do, you might not like that, but I'm in charge of the courtroom. That's why they have circuit courts. And at the end of the day, if you don't like anything I do, you can appeal me. That's why they have circuit courts, especially when we've got jurors here. But I'm not going to let you make this a dog and pony show, especially when we've got jurors here.
You even were trying to threaten me with contempt.
I am threatening you with contempt.
I need my cases. You even were trying to threaten me with contempt.
No, I am threatening you with contempt. No, because third contempt. No, do not interrupt me. Third contempt. Do not interrupt me. When I said your objections don't mean shit to me, is because you were using the word objection inappropriately. When I said your objections don't mean shit to me, is because you were using the word objection inappropriately. If you have an objection, you have to have a legal basis every time I disagree with you. For example, if you have an objection, you have to have a legal basis and you say, I object, Judge. For example, she hasn't laid a proper foundation because all she said is, Judge, I've got a video. I'd like to play it for the jury. She hasn't laid a proper foundation. Legal objection. Because all she said is, Judge, I've got a video. I'd like to play it for the jury. I object, and I say, what's your objection? Legal objection. And you just disagree with me? When I rule in her favor, and you say, I object, and I say, what's your objection? Your objection. And you just disagree with me because you're not using the word. That's why I said your objections mean shit to me because you're not using. That's what I tried to tell you originally. The first time you were here, you've never been to law school. You've never tried a case. You don't know the rules of evidence. You've never been to law school. You've never tried a case. You don't know the rules of evidence and all the other things that have to be in play and to be perfectly honest, a trial go forward appropriately, properly, and to be perfectly honest, in your best interest. I'm not spinning. All right, so let's do it this way. What motion would you like to address first? Okay, the motion to postpone. So let's do it this way. I'm not denying the jury trial. Address first. The motion to postpone, denied. I'm not denying the jury trial.
Why is it on the prosecutor to approve those things?
All right, let me stop you for a minute. What do you mean you're not going to proceed? You're here. All right, let me stop you for a minute. What do you mean you're not going to proceed? You're here. Once again, you're not answering the question I asked. You just said you will not participate. And I asked, what do you mean by that? Once again, you're not answering the question I asked. You just said you will not participate. What do you mean by that? Your reasoning, I want to know what does that mean? I'm not going to proceed. I'm not asking you to proceed with this. Your reasoning, I want to know what does that mean? So when I impanel the jury, what? You're just going to sit there and not going to talk? Proceed with this. What does it mean when you say you're not going to participate? So when I impanel the jury, what? You're just going to sit there and not going to talk? What does it mean when you say you're not going to participate? Once again, and I deny it, it's been addressed. You might not like the way it's been addressed, but then you have to appeal it. And I deny it. It's been addressed. You might not like the way it's been addressed, but then you have to appeal it. What's your objection? What's your objection to me denying your motion to postpone this trial at the last minute? What's your objection? What's your objection to me denying your motion to postpone this trial at the last minute? Hold on. Is this statement preceding all these motions you filed? Hold on. Okay. Hold on. Let me make my ruling on all of them. Statement preceding all these motions you filed? I think there's a motion to dismiss for lack of jurisdiction. Let me make my.
And here's where the courtroom power dynamic snaps into focus. The judge isn't threatening contempt to intimidate. He's enforcing control of the proceedings. Contempt isn't about disagreement. It's about refusing to answer direct questions and disrupting the court's ability to function. This is the line where things start turning dangerous for the defendant.
Did you appeal Judge Green's decision on that motion? Did you appeal Judge Green's decision on that motion? There's no appeal filed yet, correct? I'll take that as there is no appeal filed. Motion is denied then. She made the ruling. You don't get to ask me to make the same ruling. There's no appeal filed. Once again, don't interrupt me because I can go to the ruling. You don't get to ask me to make the same ruling. Judge Green, once again, don't interrupt me because I can go to exact motion and denied your motion. Judge Green, a judge in this court, ruled on that. It certainly doesn't get appealed to me. Denied your motion. Is that clear? That motion has not yet been appealed, and it certainly doesn't get appealed to me. Next motion. Is that motion to?
Yes.
Thank you. Next motion. Motion to. Yes, the judge can. Listen to me. Yes, the judge can. Then appeal her to circuit court. A judge made a ruling. You don't get to keep arguing that same motion. Appeal her to circuit court. A judge made a ruling. You don't get to keep arguing that same motion.
The things that she's claiming and saying were never set aside by national suits and the things that she's claiming and saying were never beat me. And then she comes here and makes these submissions and saying, "Well, judge said this, judge said that."
Fine, then I'll say the same. I'll say the same thing to you. Listen, fine, then I'll say the same. Your motion to dismiss for lack of jurisdiction denied. Listen, by me, you can appeal your motion because the reason she stated jurisdiction. The township by me, you can appeal me because the reason she stated court has jurisdiction over citations issued by the Township of Huron. So for that reason, I'm prepared to over citations issued by the Township of Huron. So for that reason, you can appeal my decision. I'm prepared to move forward and adjudicate that citation. Is that clear enough? So you can appeal my decision. Reconsider for bias and judicial misconduct. Denied. Would you like me to clarify that in any way? Motion to reconsider for bias and judicial misconduct. Denied. Would you like me to clarify that in any way? Then guess what? The Court of Appeals can overturn me because I'm not biased to you. Then guess what? You might not like the way I talk to you because I'm not biased to the things I say to you. You might not like the way I talk to you. Believe it or not, brother, the things I would like to save you from what's going to happen today. I'm not biased against you. Believe it or not, brother, I would like to save you from what's going to happen today. Here's my, dude, let me talk. I really would. Because here's my, you have turned what should be a fairly minor misdemeanor and civil infraction situation what should be a fairly minor misdemeanor and civil infraction situation. I don't think it's going to end well for you. Huge mess. I tried to save you from that the first day you were here when I tried to convince you to have some conversation with a court-appointed attorney. I tried to save you from that the first day you were here when I tried to convince you to have some conversation with a court-appointed attorney. I have no, and you didn't want to do all that. Ill feeling towards you whatsoever. Knowing I'm going to give you the best trial I can give you today if you decide to participate. Whatsoever. But I am not going to let trial I can give you today things in front of the jury that I determine are not relevant. But I am not going to let you drag things in front of the jury that I determine are not relevant because that's my job as the gatekeeper. Arguments that I think are just going to cloud issues if I don't think they're relevant. I'm not going to let you get into a bunch of arguments that I think are just going to cloud issues if I don't think they're relevant. My job as a judge is to run this trial because I don't like Mr. Crusoe. It's because my job as a judge is to run this trial. I'm going to step all over your toes and your beliefs. And I'm going to do that. But if I do that, I anticipate I'm going to step all over your toes and your beliefs. So I am denying your motion. But that doesn't mean I don't like you or I have bias against you. Anything else you want to put on the record so you can feel that decision? To recuse myself. Once again, stop. Anything else you want to put on the record so you can feel that decision? What you want to say is, I disagree with that, which is fine. That's why you appeal to the circuit court. What you want to say is, I disagree with that, which is fine. That's why you appeal to my ruling. But it's not an objection. That's not a legal objection to my ruling. That's not a legal objection. That's not a legal objection to a ruling. So, that's two motions down. The next one is motion for relief from judgment. I'm assuming that's Judge Martin's decision to set aside the next one is motion for relief from judgment. I'm assuming that's Judge Martin's decision to set aside the default. Do you really want me to grant that motion? Because if I grant your motion, that means the default that was set aside. Do you really want me to grant that motion? Because if I grant your motion, that means the default that was set aside. Is that really what you want today? Defaults that were set aside are reinstated. Is that really what you want today? Yes or no? You filed a motion asking me to set aside a decision that was made. Yes or no? Do you really want me to set that decision aside? Because that means those civil infractions are then in default. Do you really want me to set that decision aside? Because that means those civil infractions are then in default. Yes or no? Is that a yes or no? Do you want me to set aside those default do you want me to set aside the default set asides? Do you want me to reinstate those default judgments? Do you want me to set aside the default set asides? Do you want me to reinstate those default judgments? All right. You filed something called Notice of Constitutional Rights, which I didn't see anything where it required me to make any decisions. Notice of Constitutional Rights. You're just letting me know that you're standing on the Constitution. Required me to make any decisions or anything else. You're just letting me know that you're standing on the Constitution. We dealt with. You also file an affidavit of non-consent. Right. You didn't need to file paperwork. Stay we dealt with. You also file an affidavit of non-consent. Was that the only message I was supposed to get out of that document? You didn't consent with the prorecedings, but I got the message. Okay. Was that the only message I was supposed to get out of that document? Okay. I don't need a preachy moment. Okay. I just want to make sure I wasn't supposed to get anything else out of that affidavit other than you don't like the process. I just want to make sure I didn't.
This explanation is crucial. An objection isn't just saying, I don't like that. It has to be tied to a rule of evidence or procedure. Without a legal basis, it's meaningless. This is a textbook example of how self-representation collapses, not because the judge is unfair, but because the rules don't bend for confusion.
For example, motor vehicles pretty much a term of art in our business. Okay. Motor vehicles pretty much a term of art in our business. You can make those arguments. But you can't tell her she can't use that phrase. Well, then you can make those arguments. But you can't tell her she can't use that phrase. So if you want to make an argument to the jury that her use of the term motor vehicle is improper, so if you want to make an argument to the jury that her use of the term motor vehicle is improper, you're not going to be able to make that argument? Is that what you're concerned about? Is you're not going to be able to make the argument? Well, I can guarantee you're not getting all these filings on the record because the jury has no reason to know about all your motions. Well, I can guarantee you're not getting all these filings on the record because the jury has no reason to know about all your motions. No. No, that's not the way it works, Mr. Crusoe. No, Mr. Crusoe. No. All right, that's not the way it works, Mr. Crusoe. You don't get to tell me what my job is. I've been doing it for 25 years. All right, listen, brother, listen. You don't get to tell me what my job is. I've been doing it for 25 years. Then that's why they have appellate courts for the fourth or fifth time. Listen, I decide what. Then that's why they have appellate courts for the fourth or fifth time. I decide. That is by definition the role of the judge at a jury trial. I decide what goes in front of that jury. That is by definition the role of the judge at a jury trial. I get to decide what goes in front of that jury. That's the way it works. If you don't like the decisions I make, you appeal those decisions. Is whether or not you violated the township ordinance on that day. What this jury has to decide today is whether or not you violated the township ordinance on that day. Whether or not I should recuse myself, or whether or not you notice. None of these legal arguments about whether or not I should recuse myself, or whether or not you notice. And none of it's going to me up for constitutional rights. None of that has to go to that jury. And none of it's going to. I already ruled on that.
That's why they should have tried in my emergency stop.
I already ruled on that. Once again, I'm not trying to. I'm doing my function as a gatekeeper for a jury trial. I'm deciding what's relevant and what's not. I'm doing my function as a gatekeeper for a jury trial. I'm deciding what's relevant and what's not. But we're going to do it once again. We're going to do it my way. You can appeal me. I've been appealed before. I'll probably be appealed before I retire again. You can appeal me. That's the way the process is set up. I'll probably be appealed before I retire again. It's okay. That's the way the process is set up. I am open-minded enough to think that perhaps my mindset about I am open-minded enough to think that perhaps maybe that's all my mindset about your whole travel whole thing. Tell me I'm wrong. Maybe that's all wrong. But so far, and I've ruled this way a number of times on the traveling issue. Nobody's ever appealed me to, and I've ruled this way a number of times on the traveling issue. Nobody's ever appealed me that idea to lead to a circuit court judge to tell me I'm wrong. But I'm open to that idea.
They just keep setting aside. Exactly, it doesn't exist. Not allow me. They just keep setting aside. Exactly, it doesn't exist. Not allow me.
What's your case that traveling doesn't mean operating? What's your case that traveling doesn't mean operating?
Every way, the judicial bias.
All right. All right, then appeal me. But today we're having a jury trial.
The judicial bias.
All right. All right, then appeal me. But today we're having a jury trial. Hold on a minute. Once again, I want to know what that means. You're not participating. But hold on a minute. Once again, I want to know what that means. You're not participating.
There's bias in this board against.
Okay.
There's bias in this one against.
Okay.
I know they make you seem like they're not a big deal, and
no, your rights are a really big deal.
I know they make you seem like they're not a big deal, and
no, your rights are a really big deal.
Give this excuse to the things that are happening, the things we're aligning yourself. Give this excuse to your whole.
Mr. Purcell, no, I'm not. Listen to me. No, it's not. Listen to me. Mr. Purcell, no, I'm not. Listen to me. She could step out of the room, and I still think your travel argument is bullshit. She could step out of the room, and I still think your travel argument is bullshit. The right to travel was when you did it by Shank's mare. Traveling. The right to travel was when you did it by Shank's mare. Appeal me. When you're driving a motorized vehicle, that's my traveling in a motorized vehicle. Appeal me. When you're driving a motorized vehicle, that's my legal traveling in a motorized vehicle. That brings all those ordinances into play. I encourage you to do that. That's my legal rule. But that whole traveling argument, which, dude, I've been through that argument a whole lot more than you have. But that whole traveling argument, which in the last 25 years, I've had that argument a whole lot more than you have. Traveling as you try in the last 25 years, I've had that argument a lot. You could not be stopped by the government. Traveling as you from one venue to another meant you could not be stopped by the government from walking from one venue to another. Then the rules kicked in. But when we got motorized, then the rules kicked in.
Yes. First of all, you're all going from the American Jerusalem. It's not in this state. Yes.
Then appeal me. Take that precedent and appeal me. Then appeal me. Take that precedent and appeal me. I'm not trying to stop you from doing any of that. That's your right. I'm just trying to stop you from bogging down this jury with stuff that I've determined is not appropriate. I'm just trying to stop you from bogging down this jury with stuff that I've determined is not appropriate today. They're relevant to you. They're not relevant to me. I've made the decision. I have made the decision. Relevant to you. They're not relevant to me. I've made the decision. I have made the decision. I made that decision months ago, and you didn't appeal that. Which is not an appeal. Absolutely, I do that. No. Listen to me. Absolutely, I do that.
Listen to the irony here. The judge is openly acknowledging that this started as a minor case and escalated entirely because of resistance to the process. This is a pattern courts see all the time. Someone refuses counsel, challenges jurisdiction endlessly, and turns a simple citation into a legal avalanche they can't control.
You had free access.
He's still
to
ready to help
qualified,
you.
competent legal
You
counsel.
chose
They're still
to
here.
do
There's
this
one right there
yourself.
behind you.
That means you've got to know
He's
the
still
court
ready
rules.
to help you.
You've got to know the statutes and
You
the
chose
ordinances.
to do
You've
this
got to know
yourself.
the rules of
That
evidence.
means you've got to know the court rules. You've got to know the statutes and the ordinances. You've got to know the rules of
knowledge
evidence.
base. That's not fair to the prosecutor.
And if I help you through those,
then I'm taking
lapses
sides.
in your knowledge base.
That's
Now
not
I'm
fair
not
to
going
the
to let her walk
prosecutor.
all over you
Then
and
I'm
try to
taking
trick you because you
sides.
don't know some of those rules and
Now I'm not
statutes.
going to let her walk
But
all
I
over you
am
and try to trick you because
absolutely
you
going to
don't know
require
some
you
of
to
those
know what you're
rules
doing
and
because
statutes.
you've chosen to do it.
But I am absolutely
That doesn't
going to
show
require
bias.
you to know what you're doing because you've chosen to do it. That shows impartiality. That doesn't show bias. That shows impartiality. Once again, Mr. Crusoe, that's your opinion. Once again,
No, it's
Mr.
your
Crusoe,
interpretation of
that's
the facts.
your
So you have to
opinion.
appeal my decisions.
No, it's your
Look,
interpretation of the
dude,
facts.
the fact
so
that you're
you
not
have
in
to
a jail
appeal
cell
my
right now
decisions.
shows how impartial I am. And look, the fact that you're not in a jail cell right now shows how impartial I am.
This was all accountatory in the beginning, and then even when the son working, and then he goes to chief called me, and then he tries to get me to not pursue legal matters against the son working, and then the day that I file for, and then he tries to get me to not pursue legal matters against the son working, and then the day that I file for,
hold on. I don't doubt that it is. But I think we got into this a little bit the first time you were here, and I told you.
I don't doubt that
that's not proper.
But I think we got into this a little bit the first time you were here, and I told you.
Huron Township
That's
Police
not
Department handle
proper for
this.
this
There are
venue.
no. You can
If you
file
want
a
to
civil
complain about the way
lawsuit against me if you
Huron
want to.
Township Police
But what's in
Department
front of
handled
me?
this, there are no-
You can file a civil lawsuit against me if you want to. But what's in front of me
and two misdemeanors.
That's what's in front of me. One civil infraction and two misdemeanors. That's what's in front of me. Because I'm going to make decisions based on the facts. That jury hopefully is going to make decisions based on the facts that are presented. I'm going to make decisions based on the facts. That jury hopefully is going to make decisions based on the facts that are presented. The facts you want to get into, what facts you want to get into? The chief had some conversation you want to get into. What facts do you want to get into? The chief had some conversation with you?
My offense is based off what I was doing. It just keeps all getting my offense based off what I was doing. I don't have to produce any of that. I keep even trying to acknowledge any of it.
So hold on. I don't understand. Hold on. You want to be able to testify to this jury? I don't understand. Hold on. You want to be able to testify to this jury? I'm done hearing about bias. I'm done hearing about bias. You need to appeal me. I'm done hearing about bias. I'm done hearing about bias. You need to appeal me. I don't feel I have bias. And I've denied all these things. I've denied all these things. And I've denied all these things. I've denied all these things. Once again, Mr. Crusoe, just because I disagree with you doesn't mean I'm biased against you. Maybe I just think you're wrong. Mr. Crusoe, just because I disagree with you doesn't mean I'm biased against you. Maybe I just think you're wrong. Is it possible we could have a difference of opinion? I'm not going to...
Secretary of State will make sure
I've never brought a Secretary of State, have I?
It's so impartial. This is where this all
I've never brought a Secretary of State, have I?
Trying to get noticed. This thing talked about.
What do you want getting noticed and we're not getting noticed?
These are the things I've been trying to get noticed. This thing talked about.
What do you want getting noticed and we're not getting noticed? What? All right, listen. What are you going to do?
It's not collusion.
Jury, and I've denied all. Stop. I've denied all your motions. I'm ready to. What are you going to do? Because I'm ready to bring the jury. Are you not going to be here? Stop. I've denied all your motions. I'm ready to set the trial. Are you not going to be here? Once again, we're at $300 now. We're going to 4. I'm going to ask you the question again. Once again, ready to call the jury. We're at $300 now. We're going to 4. I'm going to ask you the question again. I'm ready to call the jury. Are you going to leave? Answer my question. I need to know how I'm going to proceed because we can have the trial if you just sit there. Didn't answer my question. I'll just tell the jury you know how I'm going to proceed because we can have the trial if you just sit there. I'll just tell the jury you decide to represent yourself and you might not say anything today. Okay. So that's why you want to go with the trial. Okay. No, let's, okay. On the record as you feel they should be. Okay. No, let's, on the record as you feel they should be.
I brought the sites that I left the sites at home and bring up the person's jurisdiction.
And hold on. Once again, I want to because he just walked in the room. Once again, I want to let you know there's a very competent. Once again, I want to because he just walked in the room. Once again, I want to let you know defense attorney here that's more than willing to help you with this if you want his help. Attorney here, defense attorney here that's more than willing to help you with this if you want his help.
Anybody showing bias,
I don't think I've shown bias. That's what we keep. Once again, you and I disagree. I don't think I've shown bias. That's America. You have to appeal me. You don't just keep. You and I disagree. You don't get to argue the same thing over and over until I agree with you. That's not going to happen. You don't just keep to argue. You don't get to argue the same thing over and over and over until I agree with you. That's not going to happen. Ideas of how the law applies in mine are vastly different towards you. But because I know that your ideas of how the law applies in mine are vastly different. But because I'm in the black robe, court judge of some higher court tells me I'm wrong. My ruling stands. That's just the reality. A circuit court judge of some higher court tells me I'm wrong. That's just the reality of it. Not by your definition, I'm not.
Not going to stand by your
Not by your definition, I'm not.
Never heard anything. Lawfully conceded. You can say that again. Never heard anything.
No, it doesn't need to be proven on the record. Show me a statute or a court rule in Michigan that says I got to prove it. No, it doesn't need to be proven on the record. Show me a statute or a court rule in Michigan that says I got to do that. Statute, Michigan statute, or Michigan court rule says I got to do that. So you're such a great legal scholar. So you're such a great legal scholar. Okay. Then I don't have it. You can file that motion to dismiss with the circuit court. Okay. Then I don't have it. You can file that motion to dismiss with the circuit court.
We're going to have a participating trial that's not.
But we're having a trial today.
There is no trial that's not impartiality. There is no impartiality. There's supposed to be here. There cannot be a fair trial.
Okay. Anything else you want to put on the record before I call the jury in?
Yeah.
Okay. Anything else you want to put on the record before I call the jury in?
Yeah.
Go ahead.
On the record.
How lengthy? Just so you know, you're putting this on the record. You're putting this on the record. I'm not listening. Just so you know, you're putting this on the record. You're putting this on the record. I'm not listening. Show kids record.
Case. This court is failing to address the critical motions I filed in this case, including motion to dismiss the lack of jurisdiction to address the critical motions I filed in this case, including motion to dismiss the race of jurisdiction to motion for relief and judgment of due process. These motions have raised both the Michigan Constitution and the U.S. Constitution, particularly the 5th and 14th Amendments. Under both the Michigan Constitution and the U.S. Constitution, particularly the 5th and 14th Amendment, affidavit of rebuttal regarding the traffic stop by Officer Merrill, which is connected to this case, and affidavit of rebuttal regarding the traffic stop citation number 24HR, which is court citation number 24HR, jurisdiction of the state in this court, which is court to address them constitute violation directly challenge the jurisdiction. Additionally, I have filed the failure to address them constitute violation of this process. Additionally, I have filed a non-waiver motion in Marbury v. Motion 5, U.S. 137, U.S. Supreme Court clearly established in Marbury v. 5, U.S. 137, I believe the court clearly established that any law repugnant to the Constitution was. I believe Murdoch v. Pennsylvania 319 U.S. 105 clearly affirmed that no state v. Pennsylvania 319 U.S. 105 and Constitution no state can impose fees or penalties for exercising constitutional right and Constitution 155 interference. Additionally, 505 U.S. 560 and 57 and 706 require that any judicial or administrative proceeding be fair, free from bias, require that any judicial or administrative proceeding be fair, free from bias, and based on serious evidence. I have serious concerns with this court has disregarded the motions and statements I have made by your honor, who has stated on record dismissing the same blatant referred by your prosecutor, who has stated on record dismissing the same blatant referred by prosecutor partiality which undermines the fairness of these proceedings. It is also significant that judge partiality which undermines the fairness of these proceedings. It is also significant that Judge State agreeing to enforce the Secretary of State makes them do that the court is this birth reduction is not acting as an Secretary of State makes them do this birth reduction is not acting as an incorrect as a body is enforcing The Secretary of State is an executive branch that is rather than influence over conditional proceedings. The Secretary of State is an executive branch and the constitutional rights over conditional proceedings, violation of separation of powers, and the constitutional rights of independent, fair trial. I have submitted body cam footage, violation of policy, hearings of officers, including estimated body cam footage, violations of chief and sub officers. These violations occurred even after Sergeant Price affirmed that my activity was lawful. Yet these violations occurred even after Sergeant Price affirmed that my activity was lawful. Yet my wife continues to hold ongoing retaliation against me and my family, which is compounded my wife compounded bias and retaliation against me and my family, which is compounded the compounded bias of office through in this case. Additionally, and request pursuant to Foreign Agent Registration Act of 1838 and the Anti-Bribery Statement request pursuant to Foreign Agent Registration Act of 1838 and the Anti-Bribery Statement request I have received no response. This lack more response raises further questions about the legitimacy, default without jurisdiction, moreover, and during proceedings, she admitted she did not understand jurisdiction terms and during further proceedings, she admitted she did not understand the terms. These actions deliberate further conflict with private off-road vehicles under deliberate attempt to mislead my private off-road vehicles. This mislabeling is an attempt to subject me to commercial regulations that do not apply to private. Mislabeling is an attempt to subject me to commercial regulations that do not apply to private. This whole ordinance was never intended for law. United States 363. When government entities operate in commercial capacity, they lose sovereign immunity and are subject to the same legal government entities operate in commercial capacity. The court's actions, including this application of commercial motor further demonstrate its court's actions, including in this application of commercial motor the supremacy clause of the U.S. its commercial interest interpretation of law mandates this court's clause of the U.S. Constitution, which is the supreme law of the land. This court, however, continues to proceed without regard which is the supreme law of protections. This court, however, continues to proceed without regard for to continue under these circumstances would be violating my rights at every stage of proceedings. To continue under these circumstances would be pending motions and viewing the jurisdictional challenge. They immediately dismissed this case on pending motions and viewing the jurisdictional challenge. They've immediately dismissed this case. So these issues made it more immediate violation and process violations. So these issues made Judge Martin, Judge Tina Green, Prosecutor Martin Foley, Officer Mary Rock, Judge Martin, Judge Tina Green, Chief Advocate Martin Foley, Officer Miro. I further assert that if this court continues to Chief Advocate Karen Township Division, I further must present this court continues to substantiate his claim without such evidence. This court has no authority to present evidence to substantiate his claim without such evidence. This court has no authority to actions would be unconstitutional and any further actions would be unconstitutional and
bring the jurors in.
Here to court this report back in session.
Mr. Crucell, just so you understand the process, we're going to do voir dire. Mr. Crucell, just so you understand the process, we're going to do voir dire. Did you have a chance to talk about the iPad? Okay.
No.
Hold on a minute, Joe. I understand that's your position, but I'm still going to explain things as they go. All right. I mean, I just want you to understand what's going on. Position, but I'm still going to explain things as they go. Understood. Right. I mean, I just want you to understand what's going on. So if you decide you want to jump in, you'll know where you're at. Know what's happening. Understood. I'm going to explain things as we go. I'm not trying to talk you into participating. I'm just letting you know what's happening. I'm going to explain things as we go for you and because if you leave, I'm going to ask you a bench warrant, and you're still going to have to deal with this down the road. Because if you leave, I'm going to ask you a bench warrant, and you're still going to have to deal with this down the road. Hold on, listen. Here, one of two things can happen today. At least this way, either they find you not guilty, and you're done. Here, one of two things can happen today if we have the trial, or they find you not guilty, and you're just filing one more appeal. Then you can file all your grievances and stuff, or they find you guilty, and you're just filing one more appeal. You've already wasted their time because they're all here. They're all here. You've already wasted their time because they're all here.
Weeks ago, things should have been addressed.
They're all here.
Process even took place.
The scheduling issue that takes place too.
Things should have been addressed before this.
But hold on. The scheduling issue that takes place. Don't interrupt. But hold on. You didn't appeal the last round of decision. You didn't appeal the decision you didn't like from Judge Martin. You didn't appeal the decision you didn't like from Judge Green. And you didn't appeal the decision you didn't like from Judge Martin. You didn't like from me. You didn't appeal the decision you didn't like from Judge Green. So here's my problem. You didn't like. I'm not going to adjourn today. The decision you didn't like from me last time. You say you're going to appeal because here's my problem. We've accomplished nothing. I'm not going to adjourn today. And we're no further to resolving these files. Because if you don't, we've accomplished nothing, and we're no further to resolving these files. Okay. Okay. Let me hold on. Let me try to educate you. Okay. Okay. You contacting the appellate court. Let me try to educate you. This should go to the circuit court. All right. You contacting the appellate court. First of all, okay. This should go to the circuit court. So, all right. You've gone. Okay. I didn't choose for you to be here, but you're here. Okay. So we have to get through it. All right. So the way it works is you don't just talk to them about an appeal. So we have to get through. You actually file and so the way it works is you don't just talk to them about an appeal. You actually file and perfect an appeal. So there is no appeal, but you didn't perfect the appeal. You started the process, but there is no appeal. So you started the process, but there is no appeal. We're going to go forward today. So. The only question is, are you going to be in the chair or not? We're going to go forward today. The only question is, are you going to be in the chair or not? Depending on what I set the bench warrant at. Can be whatever I want it to be, depending on what I set the bench warrant at. Once again. But see, you think that's bias, right? And that's me explaining to you the way the process works. You think that's bias. I could set a $10,000 cash bail. And that's me explaining to you the way the process works. I could set a $10,000 cash bail. Tells me that's got to be set aside. It's the bail. And until that's the bond I set, if I set it, that's got to be set aside. It's the bail. That's the bond I set if I set it. And I'm trying to listen, dude. I'm trying to get you to see because I've got a job to do. And I'm trying to do with you personally, dude. I'm trying to get you to see I've got a job to do. It's got nothing to do with you personally. You keep bringing this. You know, I'm having so much trouble getting through to you. I'm thinking the next step is a competency. You keep bringing this. You know. I'm having so much trouble getting through to you. I'm thinking the next step is a competency exam.
And in all the things that she's saying, she never said that. Holding that on record in front of you.
So once again,
and in all the things that she's saying, she never said that.
Then appeal Judge Green's decision. So once again,
wasn't doing this with the Secretary of State.
I've told you that at least 5 times today. If a district court judge makes a decision you don't like, you appeal it at least 5 times today. You don't just keep arguing again. If a district court judge makes a decision you don't like, you appeal it to the circuit court. You don't just keep arguing again. That doesn't get you any further along. So if you don't participate today, if you just sit there, that's fine. We'll have a trial. So you can jump in if you want to. You don't have to today. If you just sit there, that's fine. We'll have a trial. You can jump in if you want to. You don't have to. I mean, at each step of the game, I'm going to let you know what your options are. So, for example, when we do voir dire, I'm going to ask questions. I'm going to let you know what your options are. She's going to ask questions. So, for example, when we do voir dire, you can ask questions of the prospective jurors. You don't have to. She's going to ask questions of the prospective jurors. When it's time to pick the jury, you can ask if you want to. She has a certain number of challenges she can use. When it's time to pick the jury, you don't have to exercise those challenges. She has a certain number of challenges she can use. You understand that process? You don't have to exercise those challenges, but that's the way we pick the jury. Do you understand that process?
And I still have nothing trying to involve this stuff establishes that they're using these codes for that don't have with policy.
Okay, stop right there. Hold on. Stop right there. Stop right there. Stop right there. That's something new. Stop right there. Evidence you're waiting for. What are you waiting for? Stop right there. That's something new. Evidence you're waiting for. What are you waiting for? Tell me what it is. Tell me what it is. No. But what is it? You're looking for some records? Some ordinances? But what is it? You're looking for some records? Some ordinances? Hold on. In where? You don't have police reports? Hold on. In where?
I found out that they didn't help.
You don't have police reports?
That when I filed I found out that they didn't do more documents. Filing that when I filed my report that they didn't get me. Then I'm doing more filing things.
Hold on. Let me hear what you just say. Just hold on. Go ahead. Okay. Do you have any idea what he's talking about? Let me hear what you just say. Just hold on. Go ahead. Do you have any idea what he's talking about? You mean like the officer's personal notes? Had notes. You mean like the officer's personal notes?
For example,
had notes.
They're staying in your patrol car and the computer's on. Those are all main material that can't be patrol car and the computer's on. outside modes that are had the security clearance to observe outside modes that are had the security clearance to
That's not
observe.
what that's not what I'm referring to. The notes on the computer and stuff, that's not what there's even stuff that is not what that's not talking to the chief that they purposely redacted out of conversations with the notes that I when they were talking to the chief that they purposely redacted out of conversations with the notes that I personal information and data records. There were things that were stated in conversations that were taking place information and data records.
Let me stop you. During the traffic stop,
conversations that were taking place in the
let me stop you. During the traffic stop,
everything that's involved in my trial that they withheld.
okay, hold on. I'm trying to clarify. Are you talking about like how do I want to say this? Okay, hold on. I'm trying to clarify. Are you talking about like comments between two or more individuals? Personal comments between two or more individuals? Stop. But I got to understand what you mean. Logged through the traffic stop. You mean it showed up on camera and then they edited the camera? But I got to understand what you mean. Logged through the traffic stop. You mean it showed up on camera and then they edited the camera? Or edited the recording? Hold on. Comments on the incident report? Hold on. Comments on the incident report?
While the traffic stop was taking place, stuff that's being recorded. Like the while the traffic stop was taking place, stuff that's being entered. I'm in the process of getting it. I can't remember exactly what appeal it is. I'm in the process of getting it. We just cited statutes and codes, but he was supposed to tell me how and why. I mean, cited statutes and codes, but he was supposed to tell me how.
All right, so hold on. So what I'm hearing, I want you to confirm whether or not I'm hearing it correctly. I think what you just said was. So what I'm hearing, I want you to confirm whether or not I'm hearing it correctly. They're telling you that's all lien stuff and it's protected. Those comment section things that you want, is that a yes? That's all lien stuff and it's protected. Okay. Hold on. Is that a yes? That's what they're telling you? Okay. Hold on. Other one what? Hold on. Other one what?
This has been going on for all of years. This has been going on for all of years. Anything to do with anything that was an access to me. And then that's how I found out that these other anything to do with anything that I did that was an access to me. And then that's how I found out that these other everything to do with that entire traffic stop released to me. And then in my the other stuff is all
redacted from hold on. Redacted from the incident report? Redacted from hold on. The paper redacted from the incident report? Okay.
With no
the paper report that you received.
Why any of these things are redacted, and then how with no justification. That's why any of these things are redacted, and then how it is lien codes for me. What
policy?
And then they cite these lien codes for me, which I understand there's certain stuff.
What policy?
Right. So the officer kind of died. All the officers supposed to operate. They need to they go they die. So that killers and function supervisor, they need to try to install your release all my information. Killers and show policy show release all my information.
Okay, hold on. Stop. So he released everything, but not everything you want. Okay, hold on. Stop. So he released everything, but not everything you want.
Released me.
Okay.
The same process using these lead codes, not the receive those put in these.
Okay.
And do the same process using these lead codes, and that's not the receive I put in these. Trying and following all this whole time trying to get this stuff together. And I'm getting every which way and trying and following all this whole time trying to get this stuff together. And I'm getting every which way I'm being screwed.
He's raising issues that concern me. Because now we're talking about discovery requests that are raising issues that concern me, partially fulfilled. Because now we're talking about discovery requests that are being partially fulfilled.
This stop, he does have the incident report. He does have that camera for this stop. He does have the incident report. He does have that camera for. He also personally took video, dash camera what have you. Mutual. He also personally took video. There's no mutual discovery. He elected to use the what he's referring to again is the CAD route making where there's all this information. Not what he's referring to again is the CAD subscription where the incident report or back of what or anything of that. He's also talking about incidents that or anything of that. I think they were probably about. He's also talking about township attorneys done with it as opposed to township investigator. I think they were probably about 20 different township attorneys done with it as opposed to township investigator. Soft voice. So it's probably about 20 different contacts. And what I suspect he's talking about. So it's not just where. And what I suspect he's talking about where there are no police into his house or like so that's probably why those are blacked out as there are no incident where a misdemeanor was attached. So that's probably why those are blacked out as opposed to this incident where a misdemeanor was attached in an incident report. Can do that.
Okay. Anything else as far as information you requested that you don't have that you think you need? Anything else as far as information you requested that you don't have that you think you need?
I'm the base of it. I'm still now getting more stuff. Really dig into something. I'm uncovering more knowledge in these conversations that have to file more to get active. Nothing redacted because there's information or points in these conversations. Same thing with first redacted. It's not that I'm trying to get hold. And I understand that there are things that they can establish to the regular. It's not that I'm trying to get hold. These entire things that there are no way they can redact in these conversations. All these entire things that are there's no way.
How do you know?
All the information.
How do you know?
Stuff like that. The place things that are used showing first retaliation and stuff like that. And being the package because it can be used showing retaliation against.
But Mr. Crucell, with all due respect, that all sounds like a civil lawsuit against the township. But Mr. Crucell, with all due respect, that all sounds like a civil lawsuit against the township. Because I'm not going to get into all that with a jury. Because I'm not going to get into all that with a jury. I'm not going to let you get into all that with a jury. It's going to be confusing. We're not going to let you get into all that with a jury. It's going to be confusing. We're going to go down rabbit hole back to February. We set this trial 2 months ago. Go back to February. We set this trial 2 months ago. 2 months and 2 weeks. Hold on. Once again, I have to take offense to that. I'm not sweeping your judicial bias argument under the rug. I'm denying it. I have to take offense to that. I'm not sweeping your judicial bias argument under the rug. I'm denying it. No, seriously. See, it doesn't matter what you have to say. If I'm determining bias, I know what my heart is. See, it doesn't matter what you have to say. Now, if I'm determining bias, I know what my heart is. Or you grieve me to the now. Judicial Grievance Commission, that decision, right? Or you grieve me to they can look at all your facts. Judicial Grievance Commission, clear bias, right? They can. But I don't have to hear all your arguments and see all your evidence to know I'm not biased. But I don't have to hear all your arguments and see all your evidence to know I'm not biased. Okay. Sir, it's 9:02. Okay. The jury's been here since, I'm assuming, shortly after 8. Someone will show up. It's 9:02. The jury's been here since, I'm assuming, shortly after 8. Someone will show up.
I know it's not 100%.
Once again, you think it's stacked against you just because you don't agree with the way things are going.
100%.
Once again, you think it's stacked against you just because you don't agree with the way things are going.
These things have to be established.
Okay.
There has to be any.
Then stop. We're just hashing. We're hashing the same arguments again. Okay, stop. If you're right, we're just hashing. Then you've got an automatic appeal if they convict you today. If you're right, then you've got an automatic appeal if they convict you today. If you're right, and this whole thing has been nothing but a sham. If you're right, okay, bring the jury in. This whole thing has been nothing but a sham. Okay, bring the jury in. Motion who? Talking. Oh, I forgot you filed a motion. Give me just a motion. Who? Yeah. Did you see that? Oh, I forgot you filed a motion. Did you get her motion? Yeah. Did you see that? Hold on. Did you get her motion? You got a copy? You can just at least show him so he can see if he's seen it before. You got a copy? You can just at least show him so he can see if he's seen it before.
I have never seen this to me.
Take a minute to look at it.
Let's bring up. I have never.
Hold on. Take a chance to look at what you just handed me. Okay. All right. So, are you ready to argue that motion? Chance to look at what you just handed me. Okay. All right. So, are you ready to argue that motion?
I've never seen that before. There's no time to bring up all my valid. I've never seen that before.
Once again, valid as you determine them.
All my valid arguments and facts. All my
Once again, valid as you determine them.
They're saying the things they're trying to say. They have no
As you
where's
say.
the evidence,
Right. But I haven't ruled that anything she's trying to put in front of the jury is invalid.
Where's the evidence?
Right. But I haven't ruled that anything she's trying to put in front of the jury is invalid. She wants to stop you from saying anything about due process violations. Here, let's do it one at a time. She wants to stop you from saying anything about due process violations. Did you plan on telling the jury that your due process rights have been violated? Did you plan on telling the jury that your due process rights have been violated? Specifically, what were you going to tell them about your due process violations? Specifically, what were you going to tell them about your due process violations?
I don't have my defense completely in front of me because I'm trying to build up a defense suit that.
How was that provided to Mr. Crusoe last week?
A defense suit that.
How was that provided to Mr. Crusoe last week?
On Thursday, much time to respond. I did send it on Thursday, so much time to respond. I didn't receive his most recent motion.
That was filed Friday.
And I didn't receive his most recent motion.
That was filed Friday.
First last name.
So here's what we're going to do. If you decide to participate in presenting the evidence to the jury today, if you decide to participate in presenting the evidence to the jury today, we'll deal with those as a point. Then if any of these by point basis A through E's come up, I'm not deal with those as a point on a point by point basis. I'm telling you, you don't have to. I'm not. Sir, she wants me to give you a blanket instruction right now that you can't talk about any of these things that are listed in this motion. She wants me to give you a blanket instruction right now that you can't talk about any of these things that are listed in this motion. If you choose to present anything to the jury, I'm not going to do that. And one of these topics come up, she's going to choose to present anything to the jury. Judge, can we talk about that? And one of these topics come up, and then we'll talk about that. Stop me probably with an objection. Say, Judge, can we talk about that? Understood? And then we'll talk about that. All right? Anything else before we bring the jury in? You said you wanted to say something before the jury came in. All right. I thought anything else before we bring the jury in. You said you wanted to say something before the jury came in. I thought you said.
There's still one from the records and questions. The board trying to get all those hearings and everything.
How could it be crucial to the case today? How could it be crucial to the case today?
I need to understand that these proceedings involved. I need to understand.
We should probably have Caitlin.
Yeah, and she's not moving.
We should probably have Caitlin.
Yeah, and she's not moving.
All right, back on the record with the People versus Crusoe. All right, Mr. Crusoe, I just want to put on the record the conversation that we had out in the hallway with Mr. Bowditch. I just want to put on the record the conversation that we had out in the hallway with Mr. Bowditch. But I filled you. Outside of your hearing, you've agreed you're going to pay your $300 contempt charge. I put that in air quotes. I'm going to apply that towards the cost to pay this jury. You're going to pay your $300 contempt charge. I put that in air quotes. I'm going to apply that towards the cost to pay this jury panel hopefully in the next 2 minutes. Agreed. We're going to pick a date. In exchange, on our calendar, we're going to pick a road to give you plenty of chance to perfect your appeals, whatever you want on our calendar down the road to give you plenty of chance to perfect your appeals, whatever you want. But I have to say some other things. Agreed. All right. Okay. All right. You can before I took the bench. Now, but I have to say some other court-appointed work. All right. So I know that a lot of times when I did a lot of attorneys talking to their client. So I know that a lot of times when defense attorneys talking to a lot of people. In a situation where the courts provided the attorney a mental hurdle, they think because a lot of attorneys not working for them. In a situation where the courts provided the attorney, make sure you understand how this works. The attorney's not working for them, although we've worked together. So I want to make sure you understand how this works. He doesn't work for me, Mr. Bowditch. Although we've worked together for years, for years. I suppose if all three judges in this court told the Michigan Indigent Defense Council Regional that he works for, that we just don't want this guy in our courtroom anymore because he's just counsel regional that he works for, that we just don't want this guy in our courtroom anymore because he's just other than something drastic like that. He's not here. Put him somewhere else because I'm paying him and I've requested. Other than something drastic like that, okay, he's not here. His job, his client is MIDC. You understand that? Okay. I say his client because his client is MIDC to represent folks in district court. His client don't have their own attorney. I just want to make sure you understand when he's giving you advice. He's not telling you what he thinks is best for me. I just want to make sure you understand when he's giving you advice. He's not telling you what he thinks is best for me. The other thing, He's telling you what he thinks is best. He brought my offer out to you. Okay? Listen. Now, if you want to get into all those arguments that you've referenced today and the last time you were here, if you want to get into all those arguments that you've referenced you've got on the traveling argument and everything else, because what I told you earlier, I've got an open mind. I'll look at all the stuff you've got on the traveling argument and everything else, because what I told you earlier, I've got an open argument on traveling is a valid one. I don't think, I'll listen to everything you've got to tell me on that and your argument on traveling. I'll give you an entire day, but I'll listen to everything you've got to tell me on that and every other issue. But now I'll give you an entire day set aside for a trial to do all that. I want you to know that's an option. I'd like, and if you need to have some conversation with your family or Mr. Budge, I'd like a decision on that today, because when you walk out here, I'd like to have a date on the calendar or Mr. Budge, I'd like a decision on that today, because when you walk out here, I'd like to have a date on the calendar for either a bench trial or a jury trial. Earlier conversation, do you understand why I can be much more free and easy about what I let in when it's just me making? Do you understand why I can be much more free and easy about what I let in when it's just me making the decisions than it is with a bunch of jurors? Right. Go ahead.
We adjourn this. Now, Priscilla and I have had a conversation. Adjourn this. Streamline this case quite. Priscilla and I have had a conversation. I think we can streamline this case quite a bit. It's not nothing that's been covered.
Okay.
It's not simple. Nothing that's been covered. With understanding, it's just. And then if we need to proceed to a bench standing, it's just.
How far down the road?
And then if we need to proceed to a bench trial, we would.
How far down the road?
The discovery is going to take, if there's anything even possible to be retrieved, the discovery is going to take, if there's anything
probably a
even
month is too
possible to be
tight.
retrieved. But I still.
Probably a month is too tight. Okay.
I've already appealed to
Okay. Hold on. I think so. October 21 is too tight, I think. October 21, I think, is too tight. I think so. October 21 is too tight, I think. You want to go into October 21? I think is too tight.
We can, Your Honor.
Time frame wise, I don't. You want to go? I have no idea how that process is going to work, so I don't know. I have no idea how that process is going to work, so I don't know. No, you're not asking a favor. We're just scheduling a date. No, you're not asking a favor. We're just scheduling a date.
That's a Monday before. Do you?
Yeah, that was it. What is it? Gotta be something.
Caitlin,
Do you have an opening on Monday the 25th? You're not scheduled. Gotta be something. Just for a motion. Do you have an opening on Monday the 25th? You're not scheduled. We're not going to take testimony. Okay. This is just a motion hearing. We're not going to take testimony.
No,
Okay.
you don't have them that month last night.
So that'll work.
As long as you're not, no.
9 a.m. the 25th of November. So that'll work. It's the Monday before Thanksgiving. Nobody's got travel plans? 9 a.m. the 25th of November. It's the Monday before Thanksgiving. Nobody's got travel plans? Okay. So I think what I'm hearing is you think that will either be dispositive or we'll set a trial date that day. So I think what I'm hearing is you think that will either be dispositive or we'll set a trial date that day.
Yes, Your Honor. Or we'll resolve.
Okay. All right. I didn't ask. Can you pay the $300 today? Okay. And I implore you. I didn't ask. Can you pay the $300 today? All right. Anything else? And I implore you. Keep talking to him. Yeah, go ahead. Keep talking to him. All right. Anything else? All right. We're adjourned. Yeah, go ahead.
Here, and you guys ready to testify.
Understood. And you can give them my apologies. Put it all on me. So your civil infractions, and you can give them all down the road. Put it all on me. Understood. Okay. So you keep saying infractions. It's two misdemeanors down the road. Understood. Okay. I keep saying everything's adjourned. I'll make a note in the file so the cashier knows what to do with your $300. Okay, so everything's adjourned. I'll make a note in the file so the cashier knows what to do with your $300.
Let me just give you notice.
Not officially, I don't think. Did we set that at 8:30 or 9?
You said 9.
9? We set it at 9, but if he's always here early, she'll probably be here early, so get here early when we get it done with. We set it at 9, but if he's always here early, she'll probably be here early, so get here early when we get it done with. You're not late if you're not here before 9. We'll get your notice, you're good to go.
Yeah,
Okay. We'll get your notice, you're good to go.
Thank you, Your Honor.